Hello to everyone and welcome to the webinar, Competition in the Baltics, What to Know in 2021. We are very delighted to see that so many of you have registered and joined our discussion here today. I am Triinu Järviste and I am the co-head of Competition Practice Group in the law office TGS Baltic in Estonia. So for those of you who do not already know us, TGS Baltic is a Baltic-wide and full-service law office. But today here we have gathered our top specialists in competition law from all of our three offices in Tallinn, Riga and Vilnius. So for the introductory part, I would first like to introduce you all of our speakers who you can see in the video here already. So first, I would like to introduce Lauras, who is the partner, head of EU Competition and Regulatory Specialization Group in Lithuania. He can wave to you a little bit. You can see her name, his name also. So from Latvia, we have the co-head of Competition Practice Group, Māra, and also associate Vladlena. And finally, from Estonia, in addition to myself, we have Katri, who is my co-head of Competition Practice Group here in Estonia. So the agenda for today's webinar is as follows. So first, we will give you a short overview of the recent trends and developments from all of the three Baltic countries, from Estonia, Latvia and Lithuania. And then we will move on to separate presentations from platform markets in the Baltics. We will discuss limiting trade in the Baltics with regard to pricing issues. And finally, we will discuss the trade in Baltics with regard to distribution issues. I would also like to point out before we start that you can also see the questions boxed on the side. So please do not hesitate to ask all your questions in the comments section, and I will do my best to moderate all your questions to the speakers in between and after the presentations as well. So without further ado, let's move on to the first presentation today. Namely, I would first like to say a few words about the recent developments of competition law in Estonia. Because the time is so limited here today, I will not be able to go into very great detail of all the issues that I will be covering here, but I would still like to give you some ideas that you can think about. And if any of the topics raise some questions, then you can definitely ask additional questions and we can go into further detail in those. So first, I would like to say that in Estonia, competition law is kind of going through a turbulent phase. So right now we have going on a very big competition procedure reform, and it is going to change a lot the way how competition law issues are handled in Estonia. So at the moment, anti-competitive agreements are considered a criminal offense with a fine up to 16 million euros, and there's also a potential imprisonment, which we do not know that has actually been implemented ever, but it is a possibility. The abuse of dominance is considered a misdemeanor with a fine up to 400,000 euros. And because this is a criminal procedure for anti-competitive agreements, we can also see down rates that are possible. Now with competition law procedure reform, a lot will stay the same, but a lot will change as well. So what will likely stay the same is the amount of fines. At least they will still be quite big, and also there will be a possibility of down rates in the future as well. But what is likely to change is that most probably there will not be a criminal procedure anymore, and all the issues will be handled in administrative procedure. So this will mean that that the competition authority will be able to move faster in the proceedings, and the proceedings are less formal. There might also be a reduction in burden of proof for cartels, and increase in procedural rights and liberties of competition authority. But because no draft law has actually been presented, we do not yet know what will be the specifics of this reform. So we are in competition law, we are living at interesting times, and we can see what will happen in the future. So I would also like to point out one very interesting court case from just a couple of months ago. With competition law, it is very important that when an infringement has been made, for example, abuse of dominant position or anti-competitive agreement, then all the undertakings who have had some damage from deriving from this act can actually claim damages from the undertakings who are responsible for the infringements. So far in Estonia, we haven't seen too many of these damage claims happening because procedurally it has been quite difficult. Now we have quite good Supreme Court ruling from just a couple of months ago, where the Supreme Court stated that it is definitely possible to claim the difference between unfair and fair price. This was with regard to abuse of dominance. And the Supreme Court also found that they can claim other damages, for example, loss of profit. So this is a very good precedent for all the future damage actions in the future, because the Supreme Court definitely gave some invaluable clarifications with regard to these damage claims. So if an issue like this arises, you know that there is at least some good precedent. Next, I would also like to point out some court practice with regard to business secrets. This is definitely related also to my previous slide with regard to damage actions, because when a damage claim will be put into effect, you will need to get access to at least some of the information to base your claim on. One possibility is to base your claim for information on Public Information Act, which actually states that the dominant undertakings with special or exclusive rights and natural monopolies have the obligation to disclose pricing information. But now in recent court practice, the court has somewhat limited this obligation. So the court said in this case that first, it's assumed that the dominant undertaking itself can determine what is the business secret and what is not, because only the undertaking itself knows what are the factors that assure its profitability. So the court said that, of course, business secrets are production costs, contract prices with clients, but not only numbers, but also the model behind the numbers. But what was important in this case is that the court said that this obligation from the Public Information Act to disclose pricing information only applies with regard to public tasks for which the public has justified interest. So actually, this obligation to disclose pricing information was quite limited. So if, again, an issue like this arises, then you know that there is some court practice that clarifies what kind of information can be claimed and what not. Next, I would like to say a few words about the merger market and what is happening with regard to the pandemic. We can see from the numbers of merger decisions that there was some temporary caution with regard to the pandemic and the transactions, but actually it seems to be that there's quite quick recovery of the market. In the beginning of the pandemic, we actually anticipated and thought that some undertakings might start using the so-called failing firm defense. So this is a defense that can be presented in merger cases to argue that the merger is allowed because the target would otherwise exit the market. This would mean that the merger is necessary for the business, and there's no other means less destructive of competition. What we can see actually happening is that the cases, the merger cases, are largely not related to the pandemic, and actually less than 1% have gone into secondary proceedings, so this means to in-depth proceedings. So actually we haven't seen a lot of influence of COVID on merger market, but let's see what will happen, and maybe these issues will arise in the future. What is also one quite interesting factor to point out with regard to COVID and the pandemic is that because so many establishments have been shut down, this would result actually in temporarily lower turnovers for the undertakings. So this a little bit raises the question whether there will actually be a possibility to escape the merger procedures, the merger notice obligation, because the thresholds for turnover will not be exceeded just because temporarily for 1 year the turnovers were lower. So let's see. One trend, or I don't know if I want to call it a trend, but issue that we are maybe facing in Estonia is also trying to escape merger proceedings by somehow disguising obtaining control. So we have heard some talks on the market about this, for example, with regard to a recent merger plan with regard to the cinemas market. So this was a case where Group Apollo planned to purchase Forum Cinemas, but competition authority would not give its permission, and the parties gave up the merger. And now Forum Cinemas will be sold actually to its management board member. So this a little bit raises the question whether there could be some alternative plan in obtaining control. But it has to be kept in mind that when undertakings are thinking about disguising obtaining control and escaping merger procedure, then competition authority actually has the possibility to find control by other means, for example, financial dependence, employment relations, maybe even franchise, but this depends on the case, definitely. So the competition authority definitely has quite a big opportunity to find control by other means as well. And also it must be kept in mind that if there is no merger and no control is obtained, then the undertakings are still separate undertakings on the market. And if they start colluding somehow, then they must follow the cartel laws as well. So this is something to keep in mind. And for my final issue, I would like to say a few words about the state aid in Estonia, because this is definitely under constant public attention, and it's definitely a politically sensitive issue also to some extent, because a lot of questions that have arisen are a little bit political. So we definitely can see quite big increase in the awareness of the market participants in state aid issues, and definitely we can't look over COVID-19 measures because everyone wants a piece of state aid. A lot of undertakings are claiming to get state aid from the state, but of course the resources are limited. So what the recent court practice so far with regard to these pandemic measures, so to say, says is that the state is not under obligation to help undertakings by state aid measures, even in these pandemic times. And this means that the undertakings do not have the right to demand state aid. But the state still has the obligation to solve granting of state aid lawfully, and in accordance with the set rules, and take into account the purpose of the aid and the principle of equal treatment of undertakings. So we will definitely see some court practice with regard to these pandemic measures, so to say, in the future as well. But state aid is definitely very topical issue right now, and a lot of issues and arguments are being held on that front. So this is actually all from Estonian recent issues, and I would like to now give the stage on to our colleague Vladlena from Latvia, who will say a couple of words about the recent developments in Latvia. You're welcome, Vladlena.
Thank you, Katri. So I'm just waiting in a bit to have my slides on the screen. And while there is just this change of slides, I would like to just say good morning, everyone. Also, thank you for joining us today. So my name is Vladlena, and I'm competition and regulatory lawyer in Latvia. And during the next 10 minutes, I will update you on the most interesting recent developments regarding competition law in Latvia. So first, I will discuss the recent practice of the Competition Council. And second, I will also update you on the most interesting and relevant legal acts which are currently underway. So next slide, please. Let's start with the LDcargo and Latvian Railways case, which is a very recent case, and the decision is adopted just recently in February 2021. So to start with, in Latvia, as in many EU countries, railway market was subject to liberalization, and so for this reason, railway infrastructure and freight services are separated. And the cargo operator, such as LDcargo, it must act independently on the market, including from its parent company, from its shareholder, Latvian Railways. Now, in Latvia, there are 4 freight companies which provide such services as LDcargo. However, LDcargo has the highest market share of 70%, and also it is an unavoidable partner in border areas. Competition Authority has analyzed conduct of LDcargo, and it found that LDcargo has applied different pricing to its client, depending on whether this client only uses services of LDcargo in the border areas, or also it uses those services throughout the territory of Latvia. And so LDcargo incentivized having those contracts across the territory. And Competition Council found that that amounts to abuse of dominant position. That was the first accusation. And second, that LDcargo has applied some unfounded prices and charges when it applied charges for downtime of wagons owned by private persons. Now, it is a bold case. The Competition Commission has fined LDcargo for 5.6 million euros for this alleged infringement. But now, where this case becomes interesting, and why it is relevant for companies which also might not be dominant and which also might operate in other markets, is because it was a rare case when, for purposes of payment of this fine, Competition Authority applied joint liability also to the parent of LDcargo, Latvian Railways, solely because the parent is 100% shareholder. To be clear, this is a new development, and it is not a usual practice of Competition Commission, also because the legal basis for such joint liability lies not within national law, but it rather stems from EU jurisprudence. And in EU, there is this rebuttable presumption that a parent is exercising decisive control if it holds 100% of shareholder. and hence it is a single undertaking also with the daughter company, and the parent and the daughters, they should be held liable for antitrust, jointly liable for antitrust violations. And it is then up to the parent actually to rebut this presumption and show that the daughter company acted fully independently in this way. Now, unlike European Union, when the fine would be calculated from the turnover of both the infringer and its parent, here the Latvian Competition Commission has only calculated the fine from the daughter company. So it is unclear what was exactly the motive of the council when applying this joint liability. And although this case has been appealed, so this issue is not yet settled, but it definitely sends a very strong signal to companies that parents can be held liable for competition violations of their daughters. And now let's move to the next trend, which is on the next slide. And here I would not maybe go into very details of every single case, but speak of the trend as such. So in Latvian Competition Act, there is this Article 9 and the 4 in superscript, which provides the right of the Latvian Competition Council to fine companies and also fine natural persons for failure to provide data requested by the Competition Commission or failure to provide data in the amount as requested by the Commission or in due time. And now in recent cases, in recent years, the Competition Commission has shown that this article is not declarative and that the Competition Commission will not shy away for applying this article. For example, in the depot case, the Competition Commission has fined the company with 700,000 euros because during court proceedings, depot, as a respondent in that proceeding, has provided more extensive explanation as to, in comparison to what it has provided during investigation before the Competition Commission. And the Competition Commission found that this means that depot has provided incomplete data in the first case. Now this fine again has been appealed and later it has been revoked by the court, but the court hearings are still proceeding. Now another interesting case is a construction company's cartel case when there were parallel proceedings relating to the same issue. So there were criminal proceedings initiated by the Anti-Corruption Prevention Bureau, and there were antitrust proceedings before the Competition Commission. In that case, a person has refused to provide certain data, and this person has justified its refusal on the right not to self-incriminate, because provision of this data would probably be also relevant grounds in the criminal proceedings. But the Competition Council has not agreed to such grounds. It has stated that criminal proceedings and proceedings between competition councils are two separate types of proceedings, and that such non-self-incrimination grounds would not run by the Competition Council. And now the third case is also interesting. Here in this global media case, there was an investigation against TEM-LV, which is one of the distributors of Russian TV channels, and the Competition Council has asked its competitors for certain information. And one of other market players of competitors, Global Media, it has actually provided information requested by the Competition Council, but only after several times being asked. And also it has submitted this information past the deadline. And for this late submission, Competition Council has fined this company with a 7,000 euro fine. So this raises very interesting and legitimate questions of how much data can Competition Council require, and where is this line between between the obligation of a company to provide that data, but also between the rights of the company not to provide too much data and not to self-incriminate. And now I would like to also move to 3 law projects which are on the horizon now. So, and that's the next slide. So the first interesting development are draft amendments to public procurement law, which are now pending in the parliament. And what those draft law amendments introduce is that now there is a new ground for a buyer to refuse a bidder. If previously, if already now, a buyer can refuse a bidder because there is an unappealable decision, either by the competition council or by the court, which stipulates and finds that a buyer has been a member of a cartel and thus guilty of breaking competition rules, then now there potentially can be a new ground where a buyer can refuse a bidder simply because it has enough information which proves that a bidder is part of such a cartel. This means that no decision from an authority is needed for such a refusal. Now, second interesting amendment second interesting trend or development are upcoming amendments to competition law. These amendments are related to transposition of so-called ECN Plus directive, and Latvia is already late with this transposition, which needed to take place by February. And mainly, this EU directive it deals with providing more power and resources to competition authorities so that they could enforce competition law across Europe. In Latvia, those amendments are still at the level of the Ministry of Economics and not yet in the Parliament. I will not go into details of every and single amendment, but what is important for the companies, if those amendments and when they are to be transposed, is that firstly, the level of fines is likely to rise significantly because, first of all, higher fines are provided and there will be a 10% maximum amount of fines instead of 5 for prohibited vertical agreements and abusive dominance. And secondly, that now those fines will be calculated not based on national turnover of a company, but based on worldwide turnover of companies. And what is also important is that with those amendments, competition authorities would have extended procedural powers. They would be able to authorize also other institutions, such as possibly police or the Anti-Corruption Bureau, to perform procedural actions, but that they will also be able to perform procedural actions and inspect antitrust violations on behalf of competition authorities from other member states. Now let's get to the third interesting trend or development, which is on the next slide, and that is the upcoming unfair trading practices prohibition law. This new law, which is now pending in the Parliament, is and should be adopted likely by May of this year. It does two things. Firstly, it encompasses the already existing legislation, the existing unfair retail practices prohibition law, which applies to retailers in food and non-food sectors. But secondly, it also transposes an EU directive on unfair trading practices in the whole food supply chain. And so this is the main amendment, which is to be seen, is that now trading practices are regulated in all food supply chain, not only at the retail level. So they apply to all contracts and practices which cover food and agricultural agreements. And what is also interesting that the Latvian law is more strict than provided by the directive. And this is explained by encompassing already the existing regulation. And also the Competition Council will have a new procedural power, and it will be able to adopt interim measures. So it will be able actually to stop certain agreements, or it can make companies do certain things if the Competition Council finds that agreements or practices by companies are violating this legislation. This would be all from me for the trends which are now in Latvia. And with this, I would like to now give a word to Lauras, our colleague in Lithuania. Thank you so much.
Hello, everyone. Thanks, Vladlena. So I will briefly introduce the main developments in Lithuania. I hope you can see my slides, yeah? So basically, what Vladlena just introduced and Triinu touched a bit is that we have a quite huge reform ongoing across the Europe, including the Baltics. And this is mainly a result of the implementation of the ECN Plus directive. And of course, since in Lithuania and Latvia, we have administrative competition law systems, so these reforms will not be such dramatic as in Estonia, because as Triinu pointed out, in Estonia, we have the criminal competition law system. So very similar trends are in Lithuania as well, as far as joint liability in corporates are concerned. The parental liability, of course, the Lithuanian Competition Authority started to implement the joint liability in corporate groups before the amendments came into force. But we have some ongoing cases in administrative courts regarding those decisions. Based on the new legislation, the competition authority will have powers to impose liability also for sister companies, which makes, let's say, compliance more important for the companies. And we should also take into account the fact that there are many companies operating across the Baltics, meaning that the parent company might be in Estonia and the subsidiary might be in Lithuania. So there is a huge risk for the Estonian company to be involved in an investigation, to be fined by the Lithuanian Competition Authority, irrespective of the fact that the headquarters are in Estonia. So this is really, I would say, huge development for the business. And just to understand that now, after the implementation of the ECN Plus directive, it would be possible for the Baltic competition authorities to involve parent or subsidiary sister companies which operate in different jurisdictions. We have also some novelties in relation to the trade associations, because now we have a specific provision in the law which explicitly says that in case the trade association is not able to pay the fine, then it is for the members to pay this fine. And it will not be possible just to keep the trade association without any turnover and just impose very symbolic fine. And interesting thing also relating to the pan-Baltic issue is that now the Lithuanian Competition Authority can take into account and will take into account infringements which were done in other EU member states. So for instance, if the group company has infringed the law in Estonia or Latvia, so there are, on certain circumstances, possibility for the competition authority to take that into account and to treat it as aggravating circumstances. As far as leniency is concerned, so we have also some improvements in the leniency program. In very short, like we have now a possibility for the company, because before the, let's say, reform, there was also only possibility to benefit fully from the leniency program in case the competition authority has not started any investigation. Now there are some possibilities to benefit full from the leniency program, even in cases when the competition authority has already started the investigation. Of course, COVID has influenced a lot the enforcement of competition rules across the Europe as well as in Lithuania. So the competition authority in Lithuania really used a lot of tools in their hands to inform the business how they can cooperate, what are the risks. But where the messages sent to the market is that the pandemic is not an excuse for competition law infringements. There was also a public warning for trade associations that irrespective of the pandemic, the competition rules should be protected, and it's not an excuse just to form a cartels just due to the COVID. Interesting development is that the competition authority, it was actually the first case when the fines, the calculated fines were reduced so heavily. So it was a forum cinemas case, it was anti-competitive agreements case, and the competition authority took into account the fact that the cinemas were not operating for a long time, and of course they were very heavily affected by the pandemic, and the fines were reduced by 80%. So it's really a lot. Another interesting development is that during the last year, you can notice the increased focus towards grocery retailing, because the competition authorities quite frequently issuing press releases relating to the relationship between the huge supermarkets, grocery retailers, and suppliers. So it's also one of the issue areas of concern where the competition authority looks very specifically. And of course, the e-commerce. The business has to move online, and the competition authority in Lithuania, they reacted. They issued guidance for e-commerce. There were some also seminars on that topic. So e-commerce is also a very hot topic. The merger control, similarly as in Estonia, it seems that pandemic has not influenced a lot the merger market, because there are quite a lot of transactions ongoing, very complicated transactions ongoing, and the COVID had no significant impact on merger control proceedings. At the very beginning of the pandemic, the competition authority announced that there might be some delays, but in our practice, we've seen no delays just due to the pandemic. So everything went online, and the competition authority and businesses, they just started to do their business online. This year we have the increase of the filing fee. Last year we had 9,000 euros for filing fee. Now it's 11,000. In Lithuania we have every year the review of this filing fee. So now the fees increased a lot. Due to the implementation of, due to the novelties of the competition law, now we have a more specific, more possibilities for the competition authority as well as for the parties to make the process a bit longer of the merger review process. Now, if you calculate all the possibilities according to the law, now it's like you have almost 9 months, of the official review process. There were also some improvements of the stop the clock mechanism. We have this mechanism introduced a few years ago. It's being used by the competition authority. Now we have a bit modified stop the clock mechanism. And there is a very interesting new possibility for the parties to ask the competition authority to extend the merger review process, as well as for the competition authority to on their initiative to extend the process if certain conditions are met. And as I briefly mentioned, what we noticed in Lithuania is that the transactions are becoming more and more complicated. It means that the issues of the merger remedies, they pop up very frequently, and in our opinion, it's maybe becoming a new normal when the transactions, they have to be assessed by both the companies and advisors with a very careful review of potential remedies. So thanks a lot, and let's move to our next presentations.
Yes, I will just briefly cut in here because there have been some questions with regard to these three first presentations. There have been two questions with regard to public procurement and anti-competitive agreements in those. So the two questions are somewhat related to each other. The first question is with regard to joint venture agreements in public procurements and whether there have been any cases that this is forbidden to participate in public procurements by contractors via a consortium. And the second question is with regard to how to recognize bid rigging in public procurements. So from Estonian side, I can say that there have not been, to our knowledge, any very recent developments or very recent high-profile cases in these matters. But there has been one very important case from already a couple of years ago with regard to KPK and road building issue. So this was a case where two undertakings actually exchanged price information and agreed on prices with what they will go and bid for a public procurement in road building sector. And actually they agreed to file separate bids, but they agreed to include each other if they win as subcontractors. And the Supreme Court found in that specific case that this kind of, it wasn't definitely a joint venture, but this kind of agreement was allowed because it enabled the participants to actually make a lower bid. But I have to comment that this is, I think, somewhat extraordinary to get this kind of exemption from price agreement. But what was interesting is perhaps how this collusion was found out was that the undertakings actually filed in this public procurement price in elements. I think, if I remember correctly, there were 300 price elements, and maybe 270 or 97 were exactly the same. So most of the price elements that were submitted in the public procurement were the same, and this raised a lot of questions, and proceedings started. So this is also a comment on how to recognize bid rigging. Latvia and Lithuania, do you also have any recent practice in this area with regard to bid rigging or joint ventures in public procurements?
I believe this question is from Lithuania, because we have a very how to say ongoing debate, and because we had a I would say very novel case where the competition authority started investigation in relation to a lot of construction companies, and the problem was that in many public tenders the competitors participated based on the joint venture agreements, so it's like a joint bidding. The case resulted in huge fines for the two leading construction companies, PST and Rdaiva. It went to the Supreme Administrative Court, and it's still ongoing some processes regarding the fines imposed of the competition authority. But if you very closely look at the argumentation of the competition authority and the Supreme Administrative Court, so we have not participated in this case, but my understanding is that the competition authority and the courts administrative, they hugely relied on the practice formed in Scandinavia, and also of EFTA court in some, let's say, joint cooperation agreements. So as we can see, it's like at least in the Nordic part of the Europe, it's a hot topic. In Lithuania, it's a hot topic. Of course, there are a lot of issues which worry the businesses, but yeah, it's in Lithuania. It's really how to say, area where everyone talks, and you can make a seminar or conference on that, and you will attract a lot of audience. So in Lithuania, we have a decision of the Supreme Administrative Court, which is in force.
Okay, Māra, can you comment on Latvian side?
Yes, on Latvian side, it's the rights to be in a consortia, it's quite unclear. The Competition Council insists that if you are able and if you have enough resources to participate alone, you shouldn't go with others. And it also follows from the case law that in case it is not possible to make a joint venture consortia and agree that main works will be carried out in rotation order. So we had that case that consortia was built, organized with the aim to divide the works among the consortium members. So they went through many procurements like this. So it is precluded, it is found as a cartel. As regards the how to identify bid rigging in public procurement, we have guidelines from Competition Council, quite general ones, and as the main examples are where you can find similar mistakes in several offers. It is also should be suspected if the winner refuses to conclude the contract, so the next party wins the contract. Also, in cases if there are offers that are self-evidently not in compliance with the qualification criteria, so that they would never win this tender. These type of things are the relevant ones.
Okay, thank you very much. So as there are no questions anymore right now, I think we can move on to the next presentation. So Katri, the floor is yours to present your thoughts about platform markets.
Yes, hi from my side. Just a moment, I'm starting the slides. There we are. Yeah, the platform markets is definitely a very hot topic right now in Europe, as you probably have all heard from cases in EU level. If I can change the slides, I would mention a few names there. For some reason, I have a technical issue changing the slides here. So the big names, Google, Facebook, Amazon, Apple, all of them have been in one way or the other under the investigation of European Commission or national competition authorities in bigger member states like Germany or Italy over the last few years. There have been also a countless number of different reports in different countries, also on EU level, about the competition policy in digital areas and the issues that platforms and platform markets raise in general. As a reaction to that, last summer, the European Commission announced its consultations with respect to plans to start regulating ex ante the digital platforms. The DG Comp from the European Commission also came up with a plan to introduce a new competition tool that would supplement the traditional competition law tools such as the 101 case or 102 cases. So to have more powers and options to intervene even when they don't really even establish an infringement. They also thought of changing the market definition notice that has remained the same already since the 90s, and that we all probably have used in one way or the other. So, but it all seemed to happen somewhere there in Europe. Last autumn, though, also the competition authorities from the Nordic countries published a report about their views in this field, in platform markets. And this was an interesting report because they pointed out some cases that have actually happened locally in their countries too. And this actually made me at least realize that this is not only a European problem, it is a problem that or an opportunity that we all face here in the Baltics too. Before I step into the Baltics, I just mentioned briefly what have been the recent developments in the EU level. In the EU level, the EU Commission plans that they considered last year came into, or were manifested now into two new draft legislations, Digital Markets Act and the Digital Services Act, which are targeted to big players actually. The Digital Markets Act is a combination of regulatory tools and actually competition tools to a very, or competition law measures. So it would be imposed as regulatory act and not as a competition law tool that that the Commission initially envisaged. But it does borrow a lot from the recent competition cases against the big players. So it does define large gatekeepers who would be subject to this regulation, and it does set out a list of prohibited practices that the large platforms should not be doing, like bundling that Google was fined for, also with regard to use of data, things like that. And the fines for infringements are pretty much the similar as competition fines today, meaning up to 10% of global turnover. There is also a plan to introduce Digital Services Act, which will be more about content regulation and not so much competition law tool. This is probably more of interest for areas like, or for those dealing with media law and data protection rules. But definitely some new developments to keep an eye on. I won't get in further details with these because really these are developments that are ongoing and happen in the EU level. So they definitely merit a bigger discussion, but also a seminar of its own to discuss these topics. Now, let's come to why we should care about these issues at all in the Baltics. As I mentioned, it is actually the platforms also create problems locally. And what tends to happen with platforms is tipping. What this means is markets tend to tip in favor of a single platform and leave no room for competing platforms. If you think about the Estonian markets, think of ticket sales. Where would you go to buy your tickets if you want to go to theater or to a concert or look for an event or entertainment where to go? You probably think of Piletilevi. Also the service providers, theaters or concert organizers, they have to be there to reach to their customers. So inevitably, this is a platform that we all use. The same with real estate or cars or jobs, CV Online, Auto24, Real Estate KV or City24. If you want to order a cab, you probably use Bolt. So the markets tend to lean towards one or maybe two, but mostly one platform. And what happens, these large platforms become basically gatekeepers in the similar manner as the European Commission has defined Google or Facebook as gatekeeper. But these gatekeepers can also occur locally. And if we think of the Estonian case, these gatekeepers then tend to set their rules and create their ecosystem exactly as they view, and this has already created problems for local companies here too, and consumers. An alarming case of this was the Estonian real estate companies cartel from 2018. What happened there was that a large real estate platform, kv.ee, announced that it will increase its prices for allowing to advertise or put on to advertise different ads in their platform for real estate companies. And the real estate companies tried to negotiate with KVE, but KV said, I won't negotiate, I just increase the prices. As a reaction to that, the real estate companies, through their trade association, tried approaching as a single voice against this platform and said, well, if you're not negotiating with us, we will remove our ads from your platform. And on the date where the price increase was effected, the real estate companies actually did remove their ads from the platform. What happened was they didn't get the KV to negotiate with them, but actually it was found as collective boycott and price cooperation on the part of the real estate companies, and they got into trouble with the cartel investigation, which was though terminated with respect to them on the grounds of with settlements in most cases, or on the lack of fault on the basis of no guilt. But the issue was alarming, and instead of the so to say dominant platform to get into trouble, the users were the ones who got into trouble. This is one of the issues that that has arisen with respect to platforms, but platforms have also in our practice created quite a lot of interesting and complex, sometimes unexpected competition as well issues, also because they do link between each other, the service providers and users, and often they gather several service providers who are competitors themselves. So this facilitates collusion that can be regarded anti-competitive. Also, the role of the platform in between is questionable, whether it is an agent, whether it's just a mere tool in between. What is the role there, and what can it actually do or not do? So there have been cases with respect to insurance companies related to price calculation mechanisms that are used in intermediary platforms. So these cases do create novel competition issues that we have to be wary of. Also, Laura here would probably want to comment on an interesting travel agencies case from Lithuania, which also created unexpected competition issues to companies that were quite surprised that they found themselves in a cartel. Please, Laura, would you comment on that?
Yeah, sure, Katri. It was really a very interesting case. I also had a chance to work on it, and of course, it started several years ago, but now it reached the European Court of Justice. I mean, I would not go very into detail, but what is the takeaway message is that it's the same as with the trade associations. If you participate somewhere, you have to be cautious, and you have to follow what's happening in trade association or in those multi-sided platforms. So what happened? Actually, virtually all the market players in the travel agency market in Lithuania, they used so-called Turas platform, where they can had the possibility to sell their services and products. And what happened, several users of this platform, they decided just to make some technical tweaks in the system where the discounts which could be offered by the travel agents to their client were just fixed. and quite a lot of travel agencies, they had no clue what happened, because they just received an automatic message from the administrator. A lot of companies, they even have not read this message, but the competition authority started an investigation, said that everyone who participated in this system had to bear responsibility. This case reached the Supreme Administrative Court, and it went to the European Court of Justice. And the final outcome was that, of course, those companies which were aware of that fact and were like participating in this decision to fix the price and had not distanced themselves from what happened, so they received the fines. But other companies, they were just released from the responsibility. As I mentioned, it's basically the rules of competition rules. They are important both to online world and not online world. So the same with the platforms. I would make a parallel with the trade associations, where you have to be cautious what's happening at a trade association, but it's not an excuse that if other trade associations, members of trade associations are making a cartel and you were not aware of that, so usually it's not an excuse which can be used as a defense. Okay, so I understand we should move to another presentation by Māra.
Yes. Do you see now the presentation?
Not yet.
Not yet. Okay. Waiting. Hello, everyone. I will speak about the pricing. I hope the presentation is already here. So my presentation will be divided into two parts. One will be price fixing, and the other issue will be price discrimination. And all of that I will try to relate also to the online context. First, the vertical information exchanges among sellers and buyers are normally pro-competitive and absolutely legitimate.
Yes. I will just cut you off for a little second, because it seems that the slides are not being shared. Let's just try one more time.
Perfect, thank you.
Yes, can you check, Māra, if everything is okay? Now we can already see the slides are coming.
Okay.
Perfect. Sorry for the interruption, and please proceed, Māra.
Yes. So here it is, the relationship between the sellers and buyers. Normally the information exchanges are legit, and there should not be any problems. As regards resale price maintenance, of course it is precluded, and in Baltic states it's precluded by object. It's not permitted, and true price recommendation and maximum prices are allowed, of course, as long as they do not lead to, in effect, to price maintenance. There was a question in the audience whether or not you can sell directly to your competitors' sales data. With this regard, it should be recalled that direct commercially sensitive information exchanges among competitors are always precluded, and even if you are selling this data, and therefore it may be only possible to sell data to third party, and then this third party distributes this data to others in the market without possibility to relate that data to specific competitor. So it should be like aggregated and preferably historical data. With this, you always have to be quite cautious, and definitely direct data exchanges are not precluded. This will be found as a cartel. So it may happen also that through the third party exchanged information may be found as a hub and spoke cartel, where in fact the downstream competitors are exchanging their commercially sensitive information through the upstream seller, or it may also be the trade association. It may also be the trade platform. The challenge in these cases that lies to competition authorities are in evidence. As there are normally there are no direct information exchanges among competitors, and there will be only indirect and circumstantial evidence. It is difficult to draw a line, the fine line where you can find that there is a really collusive behavior among competitors, and it's not only the vertical exchanges of the information. In Latvia, we had in 2017 hub and spoke cartel. The fines were applied in a total of 7.4 million euros. It concerned the vertical and horizontal agreements between Knauf Norgips and as well between the biggest construction materials retailers, Depo, Kesko, Kuši, and Kruza. In this case, there were repeated regular recommended price lists sent by Knauf to all the retailers without objective, reasonable explanation why you have to send all the time those recommended price lists without changing things in the market. There was also found by the Competition Council threatening bonuses and discounts granted to retailers for the compliance with this resale price level. And the problem with bonuses was that there were bonuses paid, and there was a lack of reasonable explanation other than resale price maintenance for those bonuses. It was not agreed in written for what the bonuses are paid. So all the parties were explaining the best way they could those bonuses, but the Competition Council found that they are related to resale price maintenance. Evidence included email communication, personal notebooks, price lists, photos of price labels in the shops. It was all circumstantial and indirect evidence put in the whole picture by the Competition Council. And so it was really a debatable case from the perspective of the evidence and whether the burden of proof has been met in order to find this hub and spoke cartel. Initiative complaints were coming also from retailers, not from all of them, and within different intensity. The most active was Depo. It was active in supervision of competitors' prices and forwarding them to Knauf. And also it was involved in discussing recommended price levels with Knauf. So in a way, this case emerged from communication among Depo and mainly among Depo and Knauf, and then all the other retailers were kind of going with it. Retailers frequently deviated from the recommended price levels, and it was difficult to find the moments when really there was a united resale price level in all the market. In any way, the Competition Council did not see this a problem to find that there was a resale price maintenance and that there was a collusive behavior among the competitors. The court has already approved the case as regards Kuši and Kesko, and Depo case is still pending. Similar case, in my mind, very similar case, but completely different outcome. EU Commission has adopted decisions with regard to 4 manufacturers, Asus, Philips, and others, and the fines applied are 111 million euros. Commission found that there was resale price maintenance regarding online retail prices for kitchen appliances, notebooks, and hi-fi products, etc. And in this case, there was a use of sophisticated monitoring tools by the producers, effectively tracking the resale price, and that ensured very swift intervention on the side of producer in case there were deviations. And since many of the retailers, including the largest ones, used pricing algorithms that would automatically adjust the prices of the price mavericks, the manufacturer's intervention had a much larger impact on the market than just the directly targeted retailers. So the market was following this resale price level established by manufacturers and several retailers. Old habits die hard, right? And still there was a lot of email communication among the manufacturers and deviating retailers, and there were also frequent complaints by competing retailers. In Philip's case, there was even a chat where employee complains to a friend that she's required to carry out resale price maintenance. Those cases, in my mind, are really similar. However, the Commission did not see that there is sufficient proof to find a hub-and-spoke cartel. It only directed that, indicated that there are horizontal, potentially horizontal collusion. The difference is huge because so far the fines, the maximum fines applied in vertical relationship, vertical agreements in Latvia were up to 5%. And only for horizontal agreements, fines were applied up to 10%. So this means that basically the main organizer of the whole case, Knauf, received maximum twice lower fines than the horizontally involved retailers. So the qualification may be very important with regard to fines as well. Key takeaways to avoid the resale price maintenance and hub-and-spoke cartel. Don't send, accept the price recommendation, frequent ones. Object those, and don't provide bonuses that lack explanation other than resale price maintenance. Don't complain to a hub about the competitors' resale prices, and don't send monitoring data regarding competitors' prices. The more there will be communication coming from retailers or any other from downstream market, or it can be also other way around, the more there will be possibility that hub-and-spoke cartel may be found. Don't forward refer to complaints by downstream trading partners regarding their competitors, and frequently deviate from recommended price levels. Keep records of that, even though it may not alone help to escape hub-and-spoke cartel or resale price maintenance. It can be useful. And the loyalty, confidentiality, and education of employees is really crucial. The challenges of being now also in a pandemic situation is that most of the businesses are now moving online. It's clear, and in that sense, it becomes quite challenging for companies to evaluate their behavior, and also for the competition authorities to find collusive behaviors, to find abusive practices, because the Competition Council authorities now have to have a lot of sophisticated IT tools to follow the market. And in case of Baltic states where the budgets of authorities are quite limited, it might be really challenging. And one of the main issues in moving online is that more and more companies are using pricing algorithms that may create larger transparency among the market players, and thus promote collusive, potentially collusive behavior. The first type of algorithms is identical ones. On the one hand, they are competitive because they reduce the barriers for small merchants who lack resources to develop bespoke algorithms themselves. At the same time, as everyone's using the same algorithm, the same pricing mechanism, it fuels price coordination. At the same time, the pricing authority normally should remain still with the individual firm, and the firms truly competing still would fight the urge to modify their algorithm or implement discount strategies which promote short-term profits. And proving the collusion in this case is difficult given the unilateral nature of each competitor's conduct in choosing the algorithm. Of course, in the absence of more direct information exchange between the competitors. The Court of Justice of the European Union Turas case showed that only those aware of other firms using this pricing algorithm would be in a risk to be found in a collusion to involvement in a hub-and-spoke arrangement. More concerns exist where the firms delegate pricing decisions to a third party who takes such decisions by this algorithm. For example, dynamic ride-sharing platforms as Uber and Bolt. Adaptive algorithms. These create concerns of follow the leader effect in a concentrated market that's even more important. And this was also in EU Commission's cases versus ASUS and Philips, where the price increases proved to spread more broadly across the market to parties not engaged in resale price maintenance using this adaptive pricing software. So the effects of resale price maintenance in online context are much harsh than in traditional markets. Self-learning algorithms. Concerns exist that they may, in their mission to optimize profits, find that the best strategy is actually coordination. So it's very important to know your algorithm, to know your software you are using, to know what are the potential risks of competition. It is recommended to be sure that it is designed in compliance with competition law. So compliance by design principle. Personalized pricing and big data. There are concerns in monopolized markets. It may cause market foreclosure when abused by dominant firms, when they target customers through offering the targeted discounts and personalized targeted discounts, especially targeted to competitors' clients. And as well, personalized pricing may lead to exploitative abuse of dominant position towards consumers. And this is the case where it is very difficult. It is expected to be very difficult for competition authorities to follow these situations, to identify them at all, as the pricing is personalized. Here, I would like to give floor to my colleague, Laura. I've heard there are many interesting developments with regard to price fixing in Lithuania.
Actually, it's not the developments. It's again, as history shows, the tricks are the same. But yeah, we actually always have some kind of ongoing investigations in relation to price fixing. What we've noticed is the last year is that the competition authorities more and more looking at the online sales. And as I mentioned, the competition authority issued guidelines in relation to e-commerce. It's not a very extensive guidelines. It's maybe a reminder of the basic rules just for the business to understand that the same competition rules applies whether you are making business online or offline. And to the best of my knowledge, there is at least one investigation in relation to potential price fixing, online price fixing in Lithuania. Of course, it's not the public, but what we feel is that the competition authority is really active. As always, they are very keen on cases which relate to price fixing, but now maybe enforcement shift a bit to the online, which is understandable because as we all can see that during this pandemic year, the business moved from offline more to online.
Thank you, Lauris. Now we'll move to price discrimination, but is also quite, we receive many questions from the clients whether or not I may discriminate. And so the principle following from law is that dominant undertakings are prohibited from applying the similar conditions to equivalent transactions with other trading partners, thereby placing them at a competitive disadvantage. The European Court of Justice, in its recent years case law, has developed a reasonable effects-based case law with this regard by finding that price discrimination carried out by dominant undertakings is not per se precluded, and analysis of the competitive effects is a prerequisite to find abuse of dominance. A mere disadvantage does not mean that the competition is distorted or is capable of being distorted. And analysis of the whole circumstances is always required. And for example, the negotiating power of the parties, the pricing conditions, their duration, and also the possible existence of a strategy aiming at excluding trading partners. And discriminatory pricing is abusive only if it has an effect on the costs, profits, and any other relevant interest of one or more companies involved. So if there are no effect at all on the competitor, on the trading partners, then the price discrimination may not be per se precluded. And proof of actual quantifiable deterioration in the competitive situation of the customer is not required. And discriminatory pricing need not affect the competitive position of the dominant undertaking itself, meaning that it's not necessary that dominant undertaking is active also in the downstream or upstream market. Abuse of dominance cases in Latvia regarding price discrimination shows that there is still a per se approach. However, it may be explained with the specific cases. Mostly those cases concern the large monopolies of state and municipalities. And in those cases against bus stations and Latvian Post and Latvian Railway, the companies have been also involved in the downstream market. So the Competition Council kind of presumes that there has been an aim to exclude trading partners from downstream market. Therefore, it does not really engage in any analysis of the effects and also any efficiencies, potential efficiencies of price discrimination. Exemption is Knauf case, but however, this case is also a bit different as the discriminatory pricing was not the central issue. It involved a lot of measures adopted by Knauf with the aim to induce loyalty of its customers. So pricing was only one of them. Yeah, so generally, even though if you are not precluded to apply discriminatory prices, the many uncertainties remain, and the strict approach by Competition Council in Latvia recommends to carry out this individual assessment in all cases, still in the context of the relevant market, whether or not price discrimination might create some competition concerns. So now I will give floor to Katri from Estonia. They have had some interesting cases in Estonia with this regard.
Thank you, Māra. And indeed, we had a very recent case in Estonia regarding discrimination, where also the issue was that the company who was allegedly dominant was suspected of discrimination because it had made a tender offer that deviated from its public price list. And the case was started based on a complaint by a competitor. But here also the Estonian Competition Authority admitted that actually discrimination in such situation or deviation from the public price list can be also pro-competitive, because if dominant company would always have to stick to its price list and make no exemptions, no surprises, so to say, it wouldn't be able to compete, for instance, in tenders or also in direct relations with clients. So at least here in Estonia, the development is not so much to see discrimination as per se infringement, but also to look at the very facts of the case and the matter. So that's my point that I wanted to add about price discrimination. I also saw that there was a comment or question about my earlier presentation, and question about whether platforms could be regulated with respect to content or GDPR issues with competition law tools. For instance, yes, there have been cases like that in Germany, where German Competition Authority actually found Facebook dominant and claimed that it had abused its dominant position in relation to using user data in abusive manner. And even though it was mostly related to GDPR infringement, it was also found to be a competition infringement because Facebook was in this stronger position and it could take advantage of this position. And therefore, even though it should have been kind of GDPR and the data protection issue, it was also a competition issue. So yes, these kind of measures have been used to regulate platforms, but I think in EU level and the DMA and DSA will be the tools to regulate it better and without having to twist the competition law rules as they have been bent so far, and to be more straightforward and clear-cut as to how to regulate it. But I think we have now covered the pricing issues mostly. There was, I think, one more question from the audience. Should I also take that, Triinu, do you think? This was
Yes, Katri. So I can just read the question. The question was that, just to clarify, and this is probably the flip side of seller price fixing, if a product service is sold to one buyer with a specific generous discount, then a second buyer requests that same discount, and we suspect information was shared, where would we stand on that? The discount is not publicly advertised and was specific to buyer one. So Katri, feel free to comment on this as well.
I think this is more a contractual issue between the seller and the buyer. If the buyer is covered by the confidentiality obligation, then it should actually not disclose the price information, and it should be mostly a contractual issue rather than a competition issue. How it could be a competition issue is if actually the buyers do change their pricing or purchase information or purchase price information. This could be also regarding competitively sensitive information from competition law side also, and then there could be a question whether there is an exchange of anti-competitive information. But I think, yes, from the seller's perspective, the primary measure to use is a contractual tool here to say if you have in your contract with the purchaser the confidentiality clause, then you should rely on that with the buyer one. I don't know if anybody else wants to comment on that before we move on to the next and final presentation.
Good, Katri, thank you so much. Māra, do you have anything to add with regard to this last question? Or should we move on to Laura's presentation?
No, I just started to imagine how this might develop as a hub and spoke agreement.
Yeah.
You should be careful with this. Of course, just this one case hub and spoke agreement, but other circumstances should be considered. So that's all.
Thank you, Māra. Okay, but then let's move on to Laura's presentation with regard to trade and more specifically distribution issues. The floor is yours, Laura.
Thank you, Triinu. I also fully agree with Katri that this is the situation which was described as more, let's say, for contractual, because it's the how to implement those confidentiality arrangements which are in the agreement. Can you see my presentation? Yeah. So I see that we are running out of the time, but I will be very concise and try to mention some ideas we wanted to share with you. Is that there are a lot of things going on EU level, and in particular as far as some territorial supply restrictions are concerned and parallel trade. We used to hear those parallel trade cases back in the days, like pharma and maybe some other products. But it seems that as far as fast-moving consumer goods are concerned, the parallel trade is also at the top of the agenda of the European Commission, and maybe it will be for the national competition authorities as well. And this brings the possibilities for the business in Baltics like twofold. On the one hand, the companies who are supplying some goods, they have to take that into account. And the buyers, maybe they can have some additional tools, negotiations with the suppliers, just to have more possibilities to purchase the same, let's say, products across the Europe for cheaper prices. So what happened? Basically, European Commission last year, the end of the last year, published. It published a study on the territorial supply constraints. The main reason for this study was trying to understand why the prices of some fast-moving consumer goods and food products in particular, they are different in different EU member states. And what was found is that half of the surveyed EU fast-moving consumer goods resellers had experienced constraints based on their location. And actually, of course, the interest of the suppliers was also analyzed and took into the consideration, because maybe for some short period of time, certain restraints are needed in order to facilitate the new entrants into market, or in order to prevent distributors from free riding on the promotion of efforts of other distributors. But the message is quite clear that the European Commission is concerned about possible potential territorial supply constraints, which can take in many forms. And what happened after several months, actually the study was published on November of the last year, and this year in January, the European Commission announced that it started a huge investigation against the Mondelez. We know that it's like a leading global producer and supplier of coffee, chocolates, and biscuits. And the main, of course, the start of the investigation itself means nothing from the formal point of view. That, of course, the European Commission says that they have only the concerns, and that's why they started investigation. And it does not mean that the Mondelez infringed the competition rules. but the allegations are quite interesting and severe. I mean, you can see in the slide in what particular areas of business the European Commission is looking at. And of course, it's the restrictions of active sales across the different member states, potential restrictions of passive sales, payments for and bonuses for the buyers who commit themselves not to sell the products to other jurisdictions where, let's say, the prices of these products are higher, etc., etc. So, to sum up, this case is very interesting. It will be very interesting to see how the European Commission will look at those territorial sobriety constraints, how they will be interpreted, and what the position will be taken also by the national competition authorities. Because what we can understand from the study and from the public announcements of the European Commission is that it is expected that the European Commission will lead parallel trade cases, and it's understandable because the European Commission has a huge resources for that, and it's easier and maybe even more important to look at those problems at the European level and to leave some other, let's say, areas for the national competition authorities. And if we look at the distribution as such, of course, there are a lot of possibilities for the national competition authorities to look at, because the vertical restraints or vertical agreements are a very complicated area, and there are at least some investigations going across the Europe, including the Baltic states. For instance, a couple of years ago, we had the agency investigation where the competition authority looked at the agency model and wanted to understand whether it's really a so-called genuine agency or it's more a distribution. This investigation was dropped because it was concluded that it was agency model, not a distribution. But of course, the vertical restraints investigations are not so common across the Baltics. I can say maybe Katri, Triinu, Māra, and Vladlena will add me, but in my understanding, the Baltic competition authorities, they are looking more at those, let's say, the cartel cases, price fixing cases, but of course, those vertical restraints, we don't have a lot of vertical restraints opened investigation. So, of course, information exchange and distribution system is always a topic. It's important for businesses to understand that it does not mean that even, I mean, if you are in the vertical relationship, of course, as a general rule, it's okay to share some commercial data. But if you have a dual distribution model where the supplier operates also, let's say, at that retail level as well, so it might become a problem. Because if we look across the Europe, we have an interesting investigation in Denmark where the Hugo Boss and retailer, the competition authority, Danish competition authority, saw some problems in the information exchange between those companies in this dual distribution model. Exclusivity arrangements, it's always an issue whether it is legally, I mean, what are the possibilities to make an exclusivity agreements, but what we can see from the practice is that it's quite common for businesses to use the exclusivity arrangements in the areas where it's not exclusivity as such should be involved. It's more like protection of confidential information. So it's also the balancing between the exclusivity and protection of confidential information. E-commerce, of course, during the pandemic is very important, and in particular price fixing. The suppliers for some online platforms, they want to keep some price levels to control the discounting, and it's as Māra mentioned, it may result in price fixing cases. And as I mentioned, agencies also interesting area. We have some developments at the EU level. And with the review of the vertical guidelines, I believe we will have some more guidance from the European Commission. And of course, it will affect the position of the national competition authorities as well. So maybe Triinu, Māra, some few words about the vertical restraints investigations in the Baltics. Are they very common in Estonia, Latvia?
I would say that yes, we haven't seen very many vertical cases in Estonia, especially with regard to parallel trade issues. But I would say the competition authority has some very interesting cases with regard to e-commerce, especially when the seller has its own e-channel as well, and then these competitive relations and vertical relations kind of combine. So we can see some issues from that side. Māra, how about you from Latvia?
The same. We don't have many cases related to vertical restraints. Parallel trade case we had was in 2009 regarding Samsung Electronics, and since then nothing. So I agree that this is more left for the EU Commission to deal with those cases. We had a case with regard to exclusivity. Actually, we initiated that case against the Riga Satiksme in all outdoor advertising market. They had exclusivity agreements with the GC-Deco and the Pilsētas Līnijas with regard to advertising in public transportation stops, where the exclusivity was concluded for a very long time, exceeding 5 years. And so the market was kind of blocked in those bus stations. It, of course, involved the installation of new stations, so it was kind of excused by investments made in those stations. So the case ended up with commitments offered from the Riga Satiksme and all the parties involved. So no prohibition decision from the Competition Council. So these are not often cases in Latvia.
Okay, thank you so much. I can see that Katri also has a comment here. So go ahead, Katri.
Yeah, thank you. Actually, I agree that there have not been many cases, or almost no cases, in the competition authority level, but we do see parallel trade issues in counseling and advising our companies and our clients, because the tensions do arise between buyers and sellers on the one side, and even though these tensions might not always reach to the competition authority level, but these issues do merit attention and careful design in order not to end up in either in the European Commission or in the Baltic competition authorities, because the tensions are actually in the air.
Thank you, Katri, for that comment. I totally agree. So I can see that there are no other questions from the audience as well. So this concludes our webinar for today. I thank you all the speakers, and I thank all the listeners, and all the material of the webinar and the slides will be sent to you by email, so you can look forward to those. And thank you and goodbye.